Well, good evening once again and welcome to this special broadcast on the Rafale case right here on CNBC TV 18. Without wasting any time, Justice Ganguly, to you now. Just before heading into the break, we had Mr. Bhushan commenting how the Apex Court judgment relies on submissions that had been made by the government in a sealed cover. Is that the broader concern here? Does that run against perhaps the principle of transparency that we have submissions being made which the petitioners are not privy to? So essentially, the petitioner's case is being decided on facts and submissions that the petitioners don't have the chance to rebut. Does this go against principle of natural justice? Is that a concern here, the broader principle of the sealed cover? Do we need to do away with that? Justice Ganguly.
Yes, what Mr. Bhushan has said is very, very serious, because this is a highly contested matter and matter concerning large public interest. Now, in a case like this, if there are pleadings in details, as Mr. Bhushan has contended, and the judgment does not make any reference to those pleadings, but the judgment makes reference to the unsigned note which is handed over by the government, the case is virtually against the government, because the governmental action. And in this case, the government hands over an unsigned note which is not disclosed to the other side. And the other side's pleading is not taken care of in the judgment. And the matter is decided on the basis of that unsigned note. These are the allegations made by, criticism made by Mr. Bhushan. Then it's a very serious matter, in my view, very, very humble and respectful submission. It's a clear failure of the due process. In delivering a judgment, the judges have to follow certain basic rules of justice. Where matter is highly contested, as in the instant case, and the matter has a very great importance. There the courts cannot, in my very humble submission, or should not rather, decide it on the basis of unsigned notes. I mean, who takes responsibility for these things? It's not even an affidavit. If the government wants to claim privilege, then there are certain rules and regulations under the Evidence Act under which you can claim privilege. You cannot just claim privilege on the basis of documents handed over across the bar. You have to claim privilege on the basis of certain well-known procedure. If you want to say that I can't disclose these things...
Right, let's take up Mr. Soli Sorabjee's thoughts on that. Mr. Sorabjee, if I may come across to you, the question that is being essentially asked is that this practice, perhaps, of submissions being made, unsigned notes being shared across the bar, shared in sealed covers that the petitioners are not privy to, is that a practice that perhaps needs to be dispensed with in the interest of transparency, Mr. Sorabjee?
Practice of the court. There are time-honored and well-known...
Mr. Sorabjee, go ahead.
Yeah.
Yes, Mr. Sorabjee.
My good friend Prashant Bhushan has studied the judgment. He's gone in detail about it. My only submission is, if he is correct, file the judicial review, and if he is correct, the judges will, in the exercise of the power of judicial review, accede to his submissions. Hold your horses. I don't like criticizing, castigating the judgment, imputing motives to judges whilst the judicial review is pending. Surely you have confidence in the judges, and if he is correct, I'm sure the judges will correct themselves. I have no doubt about it. So hold your horses till then.
Right.
I don't like criticizing them outside court and attributing motives to them.
Right, Mr. Sorabjee. So let me, Mr. Bhushan, let me come to you. Let me take your thoughts, your final thoughts on the matter. We have a bit of a contradiction there in terms of submissions made in sealed covers, but let's discuss about the way forward from here. Mr. Sorabjee's advice is hold your horses. Review is, of course, a remedy that is currently provided to you. So is that what we can expect? Is that perhaps what's required? A review in the open court, perhaps? Would that be a suggestion going forward?
Yes, they should certainly review this judgment. They should recall it on their own. They should recall it even on the basis of this application made by the government. That application is for correction of errors, which is only allowed for correction of clerical errors. This is certainly not a clerical error. The government's application should be treated as an application for recall of the judgment. We will also file a review petition. They should recall the judgment, hear the matter afresh,
Right, so we've lost Mr. Bhushan there, but interesting breaking news coming across. Mr. Bhushan here clarifying right here on CNBC TV 18 that they too, as the petitioners in this matter, will be filing a review application seeking a recall of this entire judgment. This is over and above the correction application that has already been filed by the government. So some interesting comments there coming in from Mr. Bhushan as well as from Mr. Soli Sorabjee as well as Justice AK Ganguly. Gentlemen, we appreciate the time and the insights that you've shared with us and with our viewers. Again, we're grateful to you. But again, this is one issue that is not dying down anytime soon, as Mr. Bhushan has just conceded here, right here on CNBC TV 18, that this is a matter on which he will be filing a review application to seek a recall of the Apex Court judgment. So an important news break that coming in from Mr. Bhushan. But that's all the time that we have for. We'll continue with the news and updates right here on CNBC TV 18. Keep watching.